Today we are going to talk about the arbitrations topics for professional students ICSI. What is arbitrations? It is one kind of the resolution mechanism and resolving the arbitration is a method of resolving disputes outside the court where the parties are to submit their conflict to a neutral third party called arbitrator or a panel of arbitrators. Here, the parties may appoint a single arbitrator or each arbitrator from their own side. This is called the panel of arbitrators. The arbitrators listen to the listen to both to the sides and examines evidence, then makes the decisions. How it works out? This is the what the arbitration. Arbitrators listens to the both sides versions and also examine the same and also submitted the version evidences, verify the evidences and then makes decisions. Decision is called award. It is usually binding on the parties. It is like a court judgment. When an arbitrator gives award, then it is usually binding on the parties. It is commonly used to business contracts, commercial disputes, and even international conflicts because it is often faster, lesser formal, and more private than court litigations. Nowadays, the court litigations are more very complicated one and time consuming also. To avoid that and also the cost effective method, this arbitration methods will be used. Suppose that two parties agree to the terms and condition of the contract. If suppose any variation or difference of opinion, then they adopt that arbitrators. If two companies have disagreements over a contract, instead of going to the court, they may go for arbitration as per the arbitration clause in the agreement. In their agreement, every company or every contract is having a arbitration agreements. It specifies how the jurisdiction will be, how the arbitrator to be appointed, how single arbitrator or panel of arbitrator, everything will be disclosed here. It is as per that the arbitration act time to time force. It will applies to the this disagreements. Arbitration agreements. Section 7 definition. An arbitration agreement is an agreement by the parties to submit the arbitration all or certain disputes which have arisen or maybe between them concerning and defined legal relationship, whether contractual or not. So it may be arbitration agreement, it may be arbitration clause. But here the section 7 defines arbitration agreements. It is again by parties submit their arbitrations all or certain disputes which have arisen or may arise between them concerning a defined legal relationship, whether contractual or not. So the parties can put before the difference of opinions with the arbitrators. Arbitration agreements. Form of arbitration, it must be in writing. It can be in the force of a clause in a contract called arbitration clause or separate agreement, which is in writing. Agreement is considered in writing if it is contained a document signed by both the parties or an exchange of letters, telex, telegram, or other means of telecommunications, or an exchange of statement of claim defines where one party asserts the evidence of the arbitration agreement and the other party does not deny it. Thus, some of the arbitration agreement, how the procedure will be there, it must first condition is it must be in writing. The agreement must be in writing. It- and a clause in the, or it can be in the form of arbitration clause in the clause, a clause in a contract called arbitration clause. A separate agreement also they can provide, but also in writing. Agreement in writing is considered to be a legal valid one. agreement signed by both parties. Both parties has to sign the agreements. An exchange of letters, telex, telegrams, or other mode of telecommunications, including the electronic means, provided the record of the agreement or if suppose if it is any exchange of letters or telex or telegrams, it will also counted as a arbitration agreements. So it basically a exchange of statement of claim and defense which one party asserts and assess the evidence of the arbitration agreement and the other party does not deny it. Because in the business relationship, there may be a difference of opinion between the parties for the contract. That is why when the agreement or contract has to be signed, it is minutely explain the reasons for the nature of the business and how the it works out and the steps to be conducted and all the details, minute details to be captured. Otherwise, this kind of problem will arise and it will lead to the arbitration. And also, if arbitration there is no settlement, then it will go to the jurisdiction of the judicial courts or high court. So it is a small difference of opinions will relate to that, where the parties may not agree with that because sometimes they may tell that certain certain details, but the agreement or contract does not include those details. Suppose if the contractor wants the additional payment, then the arbitration dispute comes in. This is where the land because even minute details will differ, and that it is a very um, important for the legal professions to draft the arbitration agreement or arbitration clause or the contract so that it will create that arbitration agreement. A reference in a contract, if a contract refers to another document containing arbitration clause, the reference of the can constitute an arbitration. The contract is in writing and the reference makes it the arbitration as a part of the contract. There are two types of the arbitration agreements. Suppose a contract refer to the another document containing arbitration clause. Suppose in a contract they may mention there is a separate agreement or arbitration agreement, then it is a called arbitration clause. Or if suppose the contract itself is having a clause, separate clause, arbitration clause as a part of the contract, so it will be bound by the both parties. So now, before coming to the arbitration, we have to see that essentials of valid contract, offer and acceptance. There must be a lawful offer by one party and acceptance by the other. The offer and acceptance must be clear, definite, and also communicated properly. So these are the things where the dispute will arise. So that is why we have to very clearly say the valid contract has to be properly drafted. Lawful consideration. Considerations means something in return, goods or services, promise, etc. Suppose the consideration is nothing but if suppose I want to purchase one kind of typewriter, the computers from a company. So the company provides dispatches the computers in lieu. The company has to pay the money. That is called the consideration. A contract with the consideration is void unless it is falls under the specific exceptions. There are exceptions that a contract without consideration is generally void unless it is further falls under the specific considerations. Capacity of the parties. The parties must be competent to a contract. As per section 11, a person is competent if they are of the age of majority, sound mind, and non disqualified in law. These are the very specific one. Majority, minor, we should not enter into the contract with the minor. and sound mind. We are not supposed to unsound mind enter into contract with unsound mind because we don't know the nature of the contract and other things. Not discovered by law because if somebody is insolvent or criminally uh, criminally punished by the court are not supposed to be coming under the there. The compulsory of party is very very important. Free concerns. Consent of the parties must be free, not obtained by coercion, undue influence, fraud, misrepresentation, or mistakes. If suppose someone don't want to sell the house, if you are forcefully acquire the house, then it is not a free consent. Lawful object. The purpose of the contract must be lawful. Agreement for illegal and immoral acts are void. Means lawful objects. Every contract are lawful objects. If suppose if drug export of drugs is not a valid object, these are examples. Lawful objects means which is coming under the law, legally valid for the things. We can supply goods and services and other things is a very common one. Suppose manufacturing of goods or services, providing services are very loud. Outside that purview will be called the unlawful objects. Thank you very much for seeing this. We are going to present the second video in short.